So we stay with the line.
Just come on forward, all the way up to the little entry point. That's good. And you can just all stand anywhere there. You don't have to be in a line. Come on up, just come on up. So that just everyone has, yeah, just right here for the entryway, just so that everyone can get in. I've got good news. Is that everyone, Ashley? Okay. So I've got great news for all of you who are currently standing. You're probably only going to have to stand for about 45 minutes. We'll give you a break to sit. I'm kidding, y'all. You all are going to get to go right now. We had enough people show up that for this trial and what we are doing, that we can move forward with the jurors who are now seated. So all of you who are standing, you are free to go about your business. Before you leave, just let me say thank you. Look, we couldn't get to this number that we have, which will get us to the 12 if all of you didn't show up. So thank you so much. You've been a part of the process. Thank you for your honesty. And, you know, we know that people get this information, this summons, and they say, how do I get out of jury duty? What you can let them know is, look, they won't waste your time. They're moving you forward. We've got great clerks like Ashley who is moving things. We'll take care of you and be respectful of your time, just like we're doing right now. Y'all have a great day. And by the way, I'm not going to call your bosses and let them know. So you are free to go and you have your day that you took off for jury duty. Thank y'all very much for being here. Ruby, are you ready?
I am, Judge.
All right, we're going on the record. Ladies and gentlemen of the jury panel, my name is Tanner Neidhardt. I am the judge of the 43rd District Court. It's one of the 6 district courts that you have here in Hays County. The case about to be tried is cause number CR 220978C. This child, the state of Texas versus Mario Lee Stafford, who is charged with sexual assault. This is a 2nd-degree felony as charged, which means the range of punishment is 2 years to 20 years in the Texas Department of Criminal Justice. First, I'd like to have the attorneys announce themselves to you. State.
Philip Deaver, for the state.
Molly Smith for the state.
Ryan Jacobs for the defense.
All right. The also forgot to mention that in the range of punishment, there is a fine that cannot exceed $10,000. It is estimated that this trial will end this week. we will not go into next week based on all the information that I understand. Understand that you have all been seated in a random order. Although that full order number is how you came back in here, that was all assigned randomly. And the reason that is because what we are here to do today is to find 12 impartial and fair jurors who can sit in this jury box and make the decision about the crime that is alleged by the state. Now, how a trial works in Texas, I just want y'all to understand that. There are 2 phases. 3 if you count jury selection. So we're in phase 1, jury selection. Phase 2 is the guilt-innocent phase. And during that phase, you hear evidence about the charged offense in this case, and only the charged offense in this case. If there is a jury verdict, and remember, there will be a jury verdict. If there is a verdict of guilty, and that means that the state has proven their case to you beyond a reasonable doubt, then the next phase would be the punishment phase. That is a separate phase after your verdict on the guilt-innocent phase, and you would come back and make the decision as to punishment. Now, in Texas, a defendant may decide with his counsel that he goes to the judge or the jury to make the decision on punishment. And that is something that is required before we even start this process. In this case, if there is a guilty verdict, the punishment phase will go before the jury. And this is a good point, a good time to start speaking about some of the rights of the defendant. The fact that a defendant makes that decision is required by me. It's really required by our law. They have to make the decision before we come in here. And it in no way means that a defendant is conceding guilt at all. But why we do that is because then during the jury selection, we will need to ask you certain questions about the punishment phase. And that's why you know that in advance. But in no way is that something that can be used against the defendant, that decision. It's something that is required. But what I want to do now is get you thinking in terms of how you will make your decision. And that is based on the evidence that is in the case. Now, the evidence only comes from 2 places. The first, the witness stand. Someone will take the witness stand, they will swear an oath to tell the truth, and then they will testify to the jury. And the jury will be the sole decision makers about that witness, about the weight to be given to their testimony. And that is the first part of evidence. The second part are the materials that are admitted into evidence. So that could be the exhibits that you hear. There may be several things that are discussed, but they're not actually entered into evidence. That would not be evidence. It's only 2 places: the testimony and the materials that are admitted into evidence. So, for instance, then what you do is you take that evidence and think about this. We want people to make decisions based only on what they hear and hear, not on any outside information, not on the way they feel about a certain case, on the evidence that is presented. Remember, we talked about what they do down in Latin America, where they're making decisions down there and they don't have this jury process. We do it this way so that everything is transparent. Everything is out in the open, and only what you hear from the evidence is how you will make your decision. That is the fairness and the uniqueness of this process. So we need you all to follow and understand that you will make your decision based only on the testimony from the witness stand and the materials that are admitted into evidence, the exhibits. Then you will take that evidence and you will apply it to the law. Now, no one in here needs to know the law right now that will be given to you. At the end of the trial, Well, at the end of the guilt innocence phase, I will give you the jury charge. And in the jury charge, that tells you all of the law that applies to this case. And what you will do is take the evidence that you have heard, comes from two places, testimony, materials admitted, and you will apply that evidence to the law and come to your decision. But realize you are only using the evidence to come to that decision when applying our law that I will give you. Now you keep saying evidence. Well, yeah, because there is non-evidence that you should not use to come to your decision. So for instance, the fact that a defendant decided to go to the jury for punishment, is that evidence? Let's see a few more heads shaking. All right. Good, right? Because just think about it. This is how you should consider all these things. Is it testimony? No. Is it a material that's been admitted, an exhibit? No. So you would not use that to make any decision about the guilt or innocence. That would be non-evidence. Anything that is non-evidence, you are not to consider. Another great example of this is the defendant has an absolute right not to testify. Everyone has that right. It's one of our constitutional rights that you do not have to testify. Think of all our laws, and we have a new government come in every 4 years or 8 years, and they'll change the last guy's laws, and then the next one will come in and they'll change the laws. But you know what hasn't changed in over 200 years? The Constitution. That one piece of paper is still around. Just imagine that it protects us. And one of those rights is the right not to testify. And I want you to think about it. You have the right, you have the freedom of speech. You can go and vote. That's how you exercise your speech. But if you don't vote, are there any consequences? Does someone come to you and hold that against you? Right? That is what these rights are about. If a defendant decides that he will not testify, or his attorney tells him not to, then you can't hold it against him. And think about it this way. Would the fact that someone not testify, would that be evidence? Would that go in the evidence box? Well, is it testimony or is it materials that have been admitted? It's neither. So what that means is the fact that someone testifies or doesn't testify, you can't even talk about what you think some person might have said. And if during deliberations someone begins to talk about it, the foreperson must tell that person to stop right away. Because what they would be talking about is non-evidence. And you cannot use non-evidence to make your decision. One more example is the fact that the defendant has been charged. The charging instrument, it's called the indictment here, is just what the state brings in order to give notice to the defendant or to an accused of what they are charging him of. It is not any evidence. Again, let's use our standard. Is it testimony? No. Is it a material admitted into evidence? No. Right? So you would not bring that into your deliberations. The fact that someone has been charged, jailed, or in any way accused of a crime. And so if that would come up and say, well, this person was charged, well, that's non-evidence and you couldn't use it. And the reason that is because the defendant is presumed innocent. Now, what does that mean? It only means that when you come in here, you don't have any evidence to make a decision. Right? We've talked about that. What evidence have you heard at this point? You know that someone has been charged. And that's non-evidence. So if I ask you to take a vote right now, guilty or not guilty, what would it be? Not guilty. Right? Not guilty. You don't have any evidence. Right now, anyone who would be sitting in this position, your family member, someone you know, any of us would be presumed innocent until the point that the state presented evidence beyond a reasonable doubt. And that's the beauty of the system, is that only by what you see, the 12 of you who will be sitting in the jury box, once you have that evidence and you believe that that evidence meets all of the elements of what has been charged, then you will find someone guilty. But until that time, the person is presumed innocent. You don't have any evidence. That's what that means. And that's fair, of course. Here's the thing that I want you to understand is, in so many cases, people say, well, that is an awful crime that someone is accused of. That's right. It's a violation of our law. Whatever it is, you don't have to like the crime in order to be on a jury. We don't like the crimes. That's why our legislature has said that they are offenses. And even on the toughest cases, where it's a tough subject, you may say, well, I don't want to be on this kind of trial. But that's not the question you should be asking yourself. It's, can I be fair to the parties in this case? Can I listen to the state's evidence with an open mind? And if they convince me beyond a reasonable doubt, then I will find the person guilty. On the other side, can you be fair to the defendant and make your decision based only on the evidence that you hear in the case, not anything else? And so, you know, in this case, I've told you what the charge is. It's a sexual assault case. So many people have a certain reaction when they hear that charge. And I understand. It's a very serious charge. And it may touch some of you in some ways that you know someone who has been in that position. But the fact that anyone else has been in that position, or maybe even yourself, is not evidence in this case. You have to be able to set that aside and make your decision based just on the evidence that you hear here. And if that evidence proves to you beyond a reasonable doubt, then you will find the defendant guilty. But if the case is not proven to you beyond a reasonable doubt, or if you have a reasonable doubt, then you must find the defendant not guilty. That's how it works. Next, I want to go to the range of punishment here. If there is a guilty verdict, you know this case will go to the jury for the punishment decision. And that happens in here all of the time. That's usually how it works. And the range of punishment for this charge is 2 to 20 years in the Texas Department of Criminal Justice, and up to a $10,000 fine. Now, what I need to ask you about is your ability to consider that full range of punishment. And in order to be on a jury, on any case, you have to be able to be open to giving that full range of punishment. And this is a really good thing. I'm not asking you right now what the punishment would be, because we're not even to that phase to start with. And second, you don't know any evidence, because you'll make your decision in the punishment phase based on the evidence. So right now, you don't know and you couldn't predict. In every case, there is the full range of punishment that as you go in, you may be thinking, well, if it's this kind of case in my mind, then I would definitely give this much. And if it's this kind of case, but it's a different version of that, I would give less. That's not how it works. And this is a good thing because it gives you a lot of tools in your toolbox, right? In some places, they give you a very limited range and say, if someone is accused of this crime, this will be their punishment. We don't do that here in Texas. We give you the opportunity to hear all the evidence and decide what the appropriate punishment would be. So sometimes in a case that would be the high end of the punishment range. In some cases, after you hear all the evidence, it would be on the low end. But going into it, you have to say, I'll consider all of it because I want that in my toolbox. In this case, that also means under our laws that probation is a possibility. So if someone, even on a 2 to 20 case, if someone is punished between 2 years and 10 years, the jury can tell the judge, we want you to probate that sentence or suspend that sentence. And what it means is the person has a sentence that you have given them, 5 years, 6 years, 8 years to 10 years. But we do not want you to impose that sentence. We want you to give probation. And that, if you tell me that you want probation in this case or any case where a person is probation eligible, then I will give it. Because I'm going to listen to what the jury tells me. Okay, so understand that that is, again, just one more tool in your toolbox. So let's talk about the range of punishment here. This is a sexual assault charge. In a sexual assault case, you have to be able to consider. I'm not asking if you would give, but you have to be able to consider giving the full range of punishment. Could, in a sexual assault case, under the right circumstances, could you consider giving 20 years? That is the question. On the flip side, under the right circumstances, something that you will only know after you've heard the evidence, can you consider giving 2 years? Or, in the right circumstances, only after you hear the evidence, could you give probation? Now, right now, you have no evidence to make that decision. I'm not asking you to make it. But I need to understand that you would consider it. Look, and I want to be open to it, is what you're saying. That includes on the low end and on the high end. It includes probation. And you have to make that decision only after you've heard the evidence. But can you consider it? So, to the left side of the room, in a sexual assault case, under the right circumstances, can you consider giving 20 years in the Texas Department of Criminal Justice? If there's anyone who cannot consider the high end, please raise your hand for me. On the other side of the room, there were no hands. Is there anyone who could not consider up to 20 years in the Texas Department of Criminal Justice under the right circumstances for a sexual assault charge? There are no hands. Let's go the other direction. Under the right circumstances, and only after you've heard the evidence in a sexual assault case, can you consider, I'm not asking you to give, but can you consider and make it a possibility that someone could be, the appropriate sentence could be 2 years? Is there anyone on the left side of the room who could not consider the low end of punishment? Your number, sir?
56.
56. Now, sir, you've had no information. You don't know the evidence. You don't know to what degree this happened and all the circumstances. But you're telling me right now that under no circumstances will, whatever those circumstances are, that's not just a figure of speech, but under no circumstances of evidence would you even consider the low end of punishment.
Correct.
Okay? Anyone else? Sir, your number, please. Can you please hold up that number that you have? The number. We're now using the numbers that are there in your seats.
Yeah, 50.
No.
18, 7, 18.
Can you hold it up for me, please? Yeah, and everyone just put that in your hand in case you need to let me know. Was there someone else on this side of the room? Yes, sir. Your number, please. 4. Having heard no evidence, you've already made the decision that you could not even consider the low end of punishment. Is that what I'm hearing? You must say it out loud because she's taking down everything that we say.
Yes.
Anyone else on this side of the room? Juror number 20. You have no evidence before you. You don't know what happened, what could have happened, what didn't happen, what did happen. You're still saying, I ain't following the law. No way can I consider the low end of punishment.
Yes.
Number 20. Anyone else on this side of the room who is going to foreclose giving the low end of punishment? All right. On this side of the room, is there anyone who's telling me that they could not consider the full range of punishment to include giving the low end of 2 years in a sexual assault case under the right circumstances? On this side of the room? Very good. All right. Now, at the same time, there's also the possibility in this case, if it is shown to you certain evidence, that someone would be eligible for probation. And you must consider that. You would still give a range of punishment between 2 years and 10 years. But then you would tell the judge, we have decided that we think these circumstances warrant probating and suspending the imposition of the sentence. Is there anyone on this side of the room, on the left side of the room, who could not consider that option? Juror number 12, having heard no evidence, not knowing the circumstances, you're already telling me that in a case of sexual assault, you could not even consider giving probation. Okay. Yep. Next person. Juror number 13, not hearing any information, not knowing the circumstances of this case, not even knowing if the defendant is guilty of this crime. You are already saying that you could not consider giving probation in this sexual assault case.
Yes.
Thank you, ma'am. Anyone else on this side? 20, I got you. Anyone else on that side? Yep, I got you, 18. Juror number 41. Yep, you don't have any evidence, but you're already saying, I won't even consider it. I'm foreclosing it. Is that what I'm hearing?
Correct.
41. What we're doing here is we're trying, anyone who sits on a jury, remember what you have to make your decision on. The evidence and the law. That's why I'm having to ask these questions. The law is that someone is eligible for these things. And we have to make sure that a juror who is sitting in that box is willing to follow the law, which is that you would consider the full range of punishment. Anyone else on this side? Anyone on the other side here? Yes, sir. Juror number 61, having heard any evidence, not knowing the circumstances of this case. You're already saying you could not follow the law and even consider probation in this case.
Guilty?
That's right.
No.
Okay. Your number, please?
61.
61. $72, no evidence, don't know anything about it, you won't even consider the law.
You were correct.
Okay, 72. Anyone else? 66.
Correct.
Won't even consider it.
Correct.
You've got no evidence, but not a chance. Anyone else? All right. Look, I know these are hard questions. We're just trying to we have to be fair to everyone in this room. And if you're saying you can't do it, you can't do it. Right? And I also know, given the subject here, It's a very tough subject for many people. And it may even hit close to home. But realize that this case is not those other cases. They're not the case on TV. They're not the case in a movie. It's not the case of someone else. It is the case that will be presented to you by the state and that must be proved, even as much as you may dislike this charge or any charge, must be proved to you beyond a reasonable doubt. And on that, let me just finish up there. There is no definition of beyond a reasonable doubt. What I can tell you is it's not beyond all possible doubt. If it were beyond all possible doubt, of course, that means you were probably there. And if you were there, in any case, you would be a witness. You could not be a juror. So what the law is that the case must be proven to you beyond a reasonable doubt. And the attorneys may discuss that more with you. But you understand that in the end, everything that you will be deciding will be based on the evidence and the law that I will give you. And if you believe that that evidence proves this case beyond a reasonable doubt, you will find the defendant guilty. It's that simple. If you do not believe that the case has been proven to you beyond a reasonable doubt, or if you have a reasonable doubt thereof, you must acquit the defendant. That is how our system works. And I thank you for being a part of it and being honest with us today. State, are you ready to begin with your jury selection?
Yes, Judge.
You may. Ruby, you want to switch us?
Yes.
Else.
Ruby, can you hear me?
Yes.
Good morning, everybody. My name is Philip Hebert. I represent the state of Texas. We're here today to talk about the state of Texas versus Mario Stafford. And our goal today, this morning, for the next 2 hours, is to find 12 jurors that are going to be fair and impartial and can follow the law. You're going to hear me say those words a lot: fair and impartial and follow the law. Because at the end of the day, that's what we need the 12 people that are eventually sitting over there to do. And so we're going to ask you questions. And what we're going to ask you is a couple things, okay? When we ask questions, I number one want you guys to speak up. The most important person in the room, for all intents and purposes right now, is this person right here. She's taking down everything that we're saying, and we have to have a clean record. For appellate purposes, in case anything goes wrong, we need to make sure that she hears every word. You guys look up above you, you see those lights, they're on, they're working, and she's using those to listen to what you say and to what I say. And so when I ask you guys a question, it always helps if you can hold up that juror card that you have so that we can see your number. As it says, use your juror card and speak up, okay? She might ask you guys to stand up if you're particularly soft-spoken, just to make sure we can hear you and everybody, okay? Another thing is we want you guys to be honest, okay? I don't care what your answer is to any of my questions, okay? If you are the most biased person in the room, okay? And you just have opinions that you would not share with anybody else, okay? I want you to be honest. And it's not just because I want you to be honest, it's because the defendant deserves honest answers so that we get a fair and impartial jury, okay? So please be honest when you talk to us. They're talking over each other. Raise your hand if you got a question, and we can call on you guys. And number 6, timing is critical. When we're done with jury selection, that's it. Okay? Once you're sitting in the box, there's no ability to go back and go, ooh, actually, I should have probably told them something. I should have probably said this. Okay? You got 2 hours from now until the defense is done with their time. So if you believe that you got something that you need us to know, let us know. Okay? So, we're here on account of sexual assault. Now, who here approves of having sex with somebody who has not consented to that sex? No hands. Not surprising. Because if we did, who would be left? Nobody. Nobody could be on our jury. And you heard the judge talk about this. We don't need people, okay, that are in favor of certain laws or not. We just need people that can follow the law that's given. We just need people that are fair and impartial. Most people are going to have strong feelings about this type of case and other types of cases. You don't have to approve of a crime to serve on a jury, and you can even strongly disapprove of a crime and still hold the state to the burden. Does everybody agree with that? See some heads nodding. Yeah, it's common sense. Okay? This process isn't about expressing the most outrage about a case like this. You can be biased against people who sexually assault others generally. Okay? You can say, I don't like sexual assault. But you cannot be biased against the defendant for being accused of a crime. And let's talk about some of his rights, some of the defendant's rights before we even begin. Okay, because I want to make sure that everybody has these squared away in their mind as we talk about some of the more specifics about this type of case, the law. The defendant has the presumption of innocence, and the judge asked you earlier, okay, if we had to take a poll right now, guilty or not guilty, and I want everybody to say, okay, guilty or not guilty, what would the verdict be right now? Exactly. He's presumed innocent until the state proves beyond a reasonable doubt that they're guilty. Okay? They have the right to remain silent. The defendant does not have to say anything today, tomorrow, the whole week. And sit there quietly. You can't use evidence. He has the right to a jury trial, which we're doing right now. He has the right to discovery. Anything that the state gets, we have to turn over to the defense. Any video, any photo, any document, anything that the police tell us, we've got to give it to the defense attorney. And they don't have to give us anything. But they have the right to see everything that we have to correct this. They have the right to subpoena witnesses, to subpoena records, to call witnesses at trial, and to confront any witnesses that the state calls. Okay? And this goes back to the idea about fairness and equality. We want a fair trial. And this is how we do it in the United States. So I give the defendant every right that he has. So let's start off with the question. Okay? I think law enforcement in my community does a good job. Okay? Here's your possible answers. 1, all of the time. 2, most of the time. 3, some of the time. 4, rarely. 5, never. Okay? I'm going to go by each and every person, and we're going to get an answer from everybody. Okay? So I want you guys for the next 5 seconds to think to yourself, how would I answer that question? And I'll do 5. Okay? And then what we're going to do is we're going to go row by row. And if we're going to start with the first row, I'm going to have everybody raise their cards in the first row. And you're going to say 1, and then your answer. And then you can put your card down. And then the next person, you'll say 2, 5, 3, 4, whatever your answer is going to be. So you can say 2 numbers. Okay, first number is going to be your card number, pause a little bit, and then your number 1 to 5. Anybody have any questions? Okay, yes, sir, number 52.
When it says my community, are you specifically talking about my small community? Or are you talking about my community as a United States citizen?
That's a great question. Let's say here in Hayes County, okay? Because at the end of the day, that's what we're here today to discuss, okay? I know that we might have opinions about law enforcement around the United States, but I want to know about your thoughts on law enforcement here in Hayes County, okay? That could be Peter PD, Kyle PD, San Marcos PD, the Hayes County Sheriff's Office. Well, let's keep it here, okay? Because that's what we're here. So, row number one, let's raise your cards up. We'll start with juror number one.
2, 2, 3, 2.
4, 2. 5, 2. 6, 2.
7, 2.
8, 2.
Perfect. Row number two, cards up.
2. 10, 1.
11, 2. 12, 2. 13, 2. 14, 2.
15, 3.
16, 2.
Perfect. Row number three, cards up.
17, 2.
18, 2. 19, 2. 22.
21, 2.
22, 2.
23, 2. 24, 2.
Perfect. Row number four, cards up.
25, 2.
26, 2.
27, 2.
28, 2. 29, 2. 30,
31, 2. 32, 2.
Perfect. Cards down. Let's do row number five, cards up.
33, 2.
34, 2. 35, 2.
36, 2. 72,
38, 2.
39, 2. 48, 2.
Perfect. Row number six, cards up.
41, 2. 42, 2. 43, 2. 44, 2.
45, 2. 46, 2.
47, 2. 48, 2.
Perfect. Let's do row number one on the right side, cards up. Start with 49.
49, 2.
50, 2.
51, 2.
52, 2.
53, 2. 54, 2.
55, 2. 56, 2.
Okay, row number two.
57, 2.
58, 2.
59, 2.
62. 61, 2.
62, 2.
63, 2.
64, 2.
Row number three, cards up.
65, 2.
66, 3. 67, 2.
68, 2. 69, 2. 72.
71, 3.
72, 2.
Perfect. And last row, cards up.
73, 2. 74, 2. 75, 2. 76, 2.
77, 2. 78, 2.
79, 3. 80, 2.
Perfect. Thank you, guys. Now, we're gonna jump in, some tougher questions, okay? The question on the board says, raise your hand if you or someone very close to you, okay? Not some cousin's, boyfriend's, best friend, okay? But somebody very close to you has been a victim of sexual assault. Now, before you raise cards and anything like that, if you guys raise your card, okay, I might have some brief follow-up of just who was it, how long ago did it occur, okay? Also, if it's something that you don't feel like you can talk about in front of your 79 other best friends, you can raise your card and let me know, and we can approach after we're done with board diary, and we can talk about it after lunch, okay? But if this is somebody that you or somebody really close to you has experienced, we want to know, okay? Because your experience might be good, might be something that we need on this jury. It also might be something that means that maybe this just isn't the case for you, okay? And during number 26, when I'm done talking right now, I'll be sure to call on, okay? Just to give a quick example, okay? Just so we kind of get our mindset right on this. You know, it might seem silly, but if there was a trial, if there was a case involving the University of Texas versus Texas A&M, okay? I couldn't sit on it. I'm a graduate of the University of Texas. I fight for them every time. Doesn't matter what the evidence was, I'd say UT wins, and I've got to pay them off, okay? If that case though was the University of Wyoming versus South Carolina, okay, I can sit on that jury, I can list all the facts. I'd be the most fair and impartial jury, okay? So it matters, you know, what our personal experiences in life are, okay? And so we need to hear about those experiences. And then we're gonna ask you some follow-up questions, okay? And let's say that you yourself were a victim of sexual assault. I'm gonna ask you a couple things. One, could you set that aside and just listen to the facts and evidence in this case? And could you follow the law that's there? Because some people might say, yeah, the thing that happened to me was 40 years ago. I've gotten over it. I'm in a good space. I can still sit on this jury, listen to the facts and evidence, and be fair. I've seen that before. Some people might say, I was sexually assaulted last week, and it's still fresh in my mind. I don't want to be here. I can't be fair and impartial. I'm going to be biased. This trial is not for me. I've seen that as well. Okay? And so this is why we ask these questions. So we're going to start on this side of the room. Has anybody or somebody very close to you been a victim of sexual assault? You pulled your cards out. Okay. And hold them up until we get your numbers. Number one, you can put them down once I say it. Number two, number 9, number 18, number 20, number 22, number 15, number 23, number 24, number 25, number 26, number 29, number 32, number 36, number 41, number 42, number 43, number 45, number 46, and number 30. Okay. Now, we're going to go through these somewhat quick, okay? I'm going to ask, who was the person? Yourself, your mother, your sister, your brother, your cousin, if you're really close to them, when did it occur? And then I'm going to ask you the questions. Even knowing that that is an experience that you have, could you still listen to the facts in this case, listen to the evidence in this case, and follow the law that's given in this case? And could you still be a fair and impartial judge? Okay? Yes. Sure. 28. And before I do that, number 26, the question that you had earlier, did we answer it or did you have another question?
Yes.
Perfect. Okay. Juror number 1. Who was it and when did it occur? Yeah. Knowing that that's an experience you have, could you still be fair and impartial in this case? Okay. Juror number 2. Who was it and when did it occur?
Yeah.
How long ago? Knowing that that's an experience that you and your daughter have had, could you still be fair and impartial in this case? Okay.
Let me just say, I know he's very close to you, but I'm trying to listen too. And so if you could speak up, I have to hear and Ruby has to hear all the way back here.
And juror number 2 just did something that I want to bring up. She said it would be very hard, but then she answered no. Okay. This is kind of like if somebody asks somebody if they're present. Okay. There's no maybe. Okay. It's either yes or it's either no. Okay. If you're about to get on a plane and you ask the captain of that plane, hey, are we going to land safely? And he says, maybe. Not a good enough answer. Okay. They answer the question. Okay. And so even if you have the desire to say, I don't know, this is going to be really hard. We're going to have to get you to either a yes or a no. The answer is no, that's okay. Okay. But to be fair to the defendant, you've got to know. Okay. So juror number 2, thank you for letting us know that with those experiences, this isn't the case. Juror number 9.
Why? 20 years ago.
Okay. Knowing that experience, could you still be fair and impartial? Okay. Juror number 18.
I'm sorry.
Yes. In other words, you want to approach afterwards. Thank you. Juror number 20.
My best friend's daughter,
Okay.
about 10 years ago.
Knowing that experience, could you still be fair and impartial?
I would preface it by saying I would try
So I was, if I have to say yes or no, I'll say yes.
Okay. Turn number 22.
My daughter,
How long ago?
10 years ago.
With that experience in mind, could you still be fair and impartial in this case? And I think I could.
Yes.
Yes or no?
Yes.
Thank you. Turn number 15.
My best friend,
How long?
a couple years ago.
With that experience in mind, could you still be fair and impartial in this case?
No.
Okay, thank you. Turn number 23.
My significant other,
Okay.
was about 25 years.
I'm sorry, can you repeat the first part?
My significant other, about 25 years ago.
Thank you.
With that experience in mind, could you be fair and impartial in this case?
Yes.
Turn number 24.
My daughter,
How long?
about 7 years ago.
With that experience in mind, would you still be fair and impartial in this case?
Yes.
Okay. Turn number 25.
My wife, roughly 25 years ago.
Could you still be fair and impartial in this case?
Yes.
Turn number 26. Yes. How long ago?
20 years ago.
Could you still be fair and impartial in this case? Turn number 28.
My boyfriend is 6, that would have been 16 years ago.
Okay. Knowing that, could you still be fair and impartial in this case and listen to the facts? of the case? Okay. Turn number 29.
Myself.
How long ago? Knowing that that's an experience that you've had, could you still be fair and impartial in this case?
I'm sorry? Couldn't hear.
Could you say?
Yes.
Turn number 32.
My wife and my daughter,
How long ago?
for my wife, it was 30 years ago, my daughter, about 3 years.
Knowing that that's an experience.
I'm sorry.
That you've had. Is that something, that you could still be fair and impartial in this case?
Yes.
Juror number 36. Yes. Who was it and how long ago?
It's. I adopted daughter to my granddaughter.
And how long ago did the assault occur?
I'm sorry, Mr. Giebert, I couldn't hear you.
Sure.
She's my.
Hold on. I didn't hear what Mr.
She
Giebert.
didn't hear me, sorry. I asked, how long ago was
4 years ago.
that? Okay, and knowing that as an experience in your family's life, could you still be fair and impartial in this case? Okay, thank you. Juror number 40. Yes. When? Knowing that that's an experience that you've had, could you still be fair and impartial in today's case? And to go back,
No,
can you answer that again?
Yes.
Thank you, Juror number 40. 41,
A close friend, about 20 years ago.
could you still be fair and impartial in today's case?
Yeah.
Okay, thank you. Juror number 42,
Father,
yes. Juror number 43,
son, about 50 years ago.
okay. Could you still be fair and impartial in the case?
Yes.
Okay, thank you. 45,
Yes.
fair and impartial, thank you. Juror number 46, who was it and how long?
Daughters. About 16 years ago.
Could you still be fair and impartial in a case like this? Okay, thank you, Juror number 46. Okay, this side of the room, we're gonna do the same thing, okay? You or somebody very close to you, a sexual assault victim, please raise your cards. 53, 55, and you can put them down as a coloring number. 57, 65, 66, 68, 72, 74, 75, 76, and 80. Juror number 53. Knowing, or who was it and how long was
Sister about 30 years ago, and then I've also worked these cases for about 5 years.
it? And with that as a personal experience of yours, would you still be found impartial in this?
Probably no.
Probably not. Trying to get a firm yes or no, in fairness to the defendant, would you say no, this isn't the type of case for you?
Exactly. I'd say no.
Perfect, thank you. Juror number 55. Yes,
The daughter, Dave Ridge, 4 years.
could you still be found impartial? Thank you, juror number 55. Juror number 57,
Myself, 4 years ago.
could you be found impartial in a case like this?
Yes.
Thank you, juror number 57. 65,
A close friend of mine about 4 years ago.
could you be found impartial knowing that that's an experience that they've had?
Yes.
Thank you. Juror number 66,
Myself, 9 years ago.
could you be found impartial in a case like this?
No.
Thank you. Juror number 68, yes,
My brother, 30 years ago.
knowing that that's an experience your family's had, could you be found impartial in a case like this? Thank you, juror number 68. 72. Who and how long ago?
My daughter, 6 months ago.
Knowing that that was something this recent. Thank you.
I didn't get a response.
6 months ago, and no.
Thank you.
Juror number 74.
Oh, my mom, 30 years ago, or 32 years ago.
Knowing that that's an experience that they've had, could you be found impartial in this?
Yes.
Juror number 75. Yes, who was it and how long ago?
This is me, and it was 67 years ago. And no.
Thank you. Juror number 76.
Myself, 4 years ago.
Could you be found impartial?
Yes.
And juror number 8.
My daughter and most of my sons. My daughter was 3 years ago, and both of my sons was 25 years.
Could you be found impartial in sex assault cases like this?
Yeah.
Thank you. What about anybody accused of sexual assault? Okay. Same question. I'm going to start on the left side. You or somebody that you know has been accused of sexual assault. That's the case consideration case. Okay, thank you. We'll put those down. And on the right side, accused of sexual assault. You or somebody else. Okay, juror number 16. Who,
My nephew.
knowing that that's something that he's been accused of, could you be found impartial in a case like this today? Juror number 43. Okay, knowing that that's something that they've had to go through, could you be found impartial in a case like this? Juror number 46. Who, and knowing that that's something that they're dealing with, could you be fair and impartial still? Thank you. Somebody that you know is a sex offender, has to register every year. Does anybody know somebody like that? On the left side of the room. 17, 20, 43, 32. Thank you. On the right side of things. 54. Juror number 17, who do you know?
My best friend, 7.
Okay, would you still be able to be fair and impartial? Okay. Juror number 20,
I have 2 acquaintances that I know,
okay,
but yes, I still could be.
thank you. Juror number 32. Who do you know?
All in all.
Could you still be fair and impartial?
Yes.
Juror number 43,
Same neighbor.
objection, and yes. Thank you. And 54. Could you still be fair and impartial? Yes, yes. Thank you.
I didn't get a response.
Yes.
Thank you.
Is there anybody that cannot sit in judgment of another human being? I know that there are some religious practices, some people that just say, I can't sit on a jury. I don't believe that you have the right to judge other people. Is anybody in this room believe that? At the end of the day, can you be fair and impartial and still follow the law? We've heard, even just now, the range of experiences that people have had. We've heard the range of emotions that people have had about cases like this. And people have been honest, saying, yes, even though that's been an experience in my life, I can still hear the evidence and follow the law. We've heard some people that have said, no, this is not the case for me. I cannot do it. Last chance on the questions that I just asked. Is there anybody that didn't raise their card saying, you know what, now that I think about it, this is not the case for me? Okay, well, that's turn number 42. You're somebody that we're gonna have approach later. Is that something that you still want to talk about? Okay. Even with your experiences and biases. Does anybody know the following four people? Either Mario Stafford, Angelica Van Zandt, SMPD Officer Tyler Crum, or SMPD Detective Brady Temple? Anybody know any of those individuals? Before we go to the next one, does anybody know anybody else in this room? Juror number 8, who do you know?
Defense Attorney Ryan Vickers.
Okay, how do you know him?
I know him very well. He's a very good friend of mine, and he's also one of my attorneys.
Okay. Knowing that that's a relationship that you guys have, could you still sit on this jury, hear the evidence, hear the facts, and only make your determination based on the facts and evidence and the law? Or do you think that that knowledge of each other would potentially make you biased in this?
I do feel it would possibly make me biased to compromise my integrity.
Okay, thank you for being honest about that. Did I see a card over here? No, okay, 32 then. You know?
Juror number 63.
Okay.
We work together.
Sounds good. Jury number 63, you agree you guys work together? Okay. For both of you guys, would, if you guys both ended up on the jury, would your relationship be such that you would take whatever he said to be more than what anybody else on the jury said? I'm saying the other way around. Would you be able to work cordially with him
Yes.
and not let it influence your own personal decision on this?
Yes.
So I'll ask each of you guys individually. So jury number 32, could you follow the law and the facts fairly?
Absolutely.
Jury number 63?
Yes.
Right. Okay, we'll go in number order. 45, who do you know?
Sure.
Okay, jury number 50, do you know, jury number 45?
Yes.
How do you guys know each
Good friends.
other? Okay, same questions to the coworkers. Knowing your relationship, would you be able to, if you ended up on the jury at the same time, would you be able to still follow your own intuition and thoughts, or would you put more weight on anything that your friends?
Follow my own intuition.
Okay, jury number 45, same question to you. Would you be able to follow your own intuition or thoughts, follow the law, listen to the evidence, or would you give more weight to something 50 said? Okay. Jury number 48.
Just a couple of more people here.
Can you tell us the numbers, you guys, in the 48?
Gentleman in uniform and gentleman in the.
Number 8?
Sure.
Yes. How do you guys know each other? Number 8?
Still.
Gotcha. You both work at APD, correct? Jury number 77, do you know jury number 48?
That's number 8, so my neighbor.
Okay. If any combination of you three ended up on this jury together, would you be able to only listen to the facts, only listen to the evidence, and follow the law, or would your relationship give more credibility to something that either of you guys said, follow the law? Number 77 says follow the law. 48?
Absolutely.
Our relationship with them is not normal.
Okay, thank you. 54, 39.
The sheriff also.
How do you know, number 77?
His brother and my son played ball here for years.
Okay.
I'm sorry, I can't hear you, sir.
Say it again.
His brother and my son played ball together in high school, and he would come to the game, just talking and game friends.
If you were both on the jury together, would you give more weight to anything that he said, or would you listen to the evidence, follow the law, and apply your own reasoning?
My own instinct.
Sir, louder, please. I can't hear
I
you.
would follow my own instinct. Yes.
Thank you.
Anybody else? No, anybody else? on this? Okay. Juror number 1. If I ask you this question, what does a sex offender look like? What would you say? And why is that? Exactly. Juror number 2, could it be a man? Could it be a woman? Could it be somebody famous? Juror number 3, do you recognize any of the people that are up there on that screen? Would you agree with jurors number 1 and 2, that the idea of sex offender could be anything? Okay. Let's talk about what that law is then in Texas, okay? Juror number 8, 48, 53, and 77, I'm sorry if I pick on you guys, but as law enforcement agents, you probably expected this stuff. Juror number 8, what's the difference between rape and sexual assault?
In the law,
Yeah, in the law.
is sexual assault in the law, there's no such thing like the word rape.
Correct. Here in Texas, rape is a colloquial, okay? It's not an actual offense. In Texas, what we have in the law, in the penal code, is sexual assault, okay? Now, if we use those terms interchangeably, you know that what we're talking about is sexual assault. And these are the elements that the state has to prove that the defendant committed that offense, okay? And when I say the word elements, you can think of it kind of like a checklist that the state has to check every time. We have to prove that on or about a certain date, the defendant, number 2, intentionally or knowingly, number 3, caused the penetration of the anus or sexual organ, number 4, of another person, number 5, by any means, and number 6, without the other person's consent. That's how we prove sexual assault in the state of Texas. One thing that I want to point out is we don't have to prove motive, we don't have to prove why they did it, just that it happened. So let's talk about some of those. There are several ways that you can commit this offense. It can either be by penetration with the male sexual organ. It can be by digital penetration or by using fingers, or it can be by penetration with an object. But there has to be no consent, okay? So what does penetration by any means mean in the state of Texas? So number 5, what do you think that penetration means? How do we prove penetration?
By force?
Okay, by force. Juror number 6, what do you think? Okay, juror number 7, what do you think? What does penetration mean? How would you describe that?
Like you said, the male sexual organ or, whatever they have it for.
Okay, juror number 8, how far does the penetration have to be?
Not far at all.
Not far at all. In the state of Texas, the slightest breach of the plane is sufficient, okay? I'm gonna use sports analogies because I think it illustrates this point well, okay? For those of you that watch football, okay? All you've got to do is get the nose of the ball past the end zone line. Doesn't need to be the full ball, just a part. Okay, with tennis, the slightest bit over the line, and that ball is in or out, okay? The same is true in the state of Texas when it comes to penetration, okay? The slightest breach of the plane of the female sexual organ, or vice versa, if a female is assaulting a male, the slightest breach is enough to prove penetration. Does anybody have a problem with that? Does anybody say, nah, I feel like it has to be more? Okay. Now I want to talk about one that likely will get the most discussion. In Texas, we have to prove that sexual assault occurred without the other person's consent. Juror number 9, what does it mean to not have consent when it comes to having sex? What would you say? Okay, not give explicit permission. Juror number 10, what do you think? What's without consent?
I would agree with his statement.
Okay, juror number 11? Saying no. Okay, juror number 12? You're shaking your head, you agree?
I'm sorry.
Say no.
Thank you.
Would it surprise you if I told you that in the state of Texas, saying no is not enough to prove without consent? Juror number 9, you're shaking your head, that doesn't shock you, right?
There's quite a few reasons. These are key points in mind.
Okay. Sure. Juror number 13, what do you think? The idea of just saying no is not enough to prove without consent.
I should agree with that.
Okay. Juror number 14, have you heard that? No means no. In the state of Texas, the legislature, okay, in their infinite wisdom, has actually given us a list of things. And they say that this list of things tells us when there is no consent, okay? And if that thing is not on that list, it does not, we cannot use it to prove that there wasn't consent. And one of the things that's not on that list is just saying no, or saying so, okay? So what are things on that list? Juror number 15, what do you think is on that list? Ways to prove that it's without consent. Okay, juror number 16, any thoughts, any ideas?
Bruises.
Okay,
Pain.
bruising, yes, one of the things, the actor compels the other person to submit or participate by the use of physical force, violence, or coercion. That's one way that the state can prove that an assault happened without consent, okay? Juror number 17, any other reasons that you can think that we could prove that it was without consent? Okay,
I'm sorry. I didn't hear that.
Her fighting involved.
Thank you.
juror number 18, any other ways that you think you could prove it? Sure, and that's fair. I think even when I tell my friends that this is how the law works in the state of Texas, they're shocked. Another way to prove it is if the actor threatens to use force and the actor has the ability to execute it, okay? The actor's holding a gun and the victim knows that they can use it, okay?
Victim knows.
They could use it.
Thank you.
The actor says, if you don't, I will beat you up. And that actor is physically fit enough to follow through on that, okay? The other person hasn't consented, and the actor knows that the other person is unconscious or physically unable to resist, okay? Juror number, I think we're gonna be about 19. Does that make sense to you? If the victim is intoxicated and the defendant knows that, that could be a way to prove it was without consent. The other person has not consented, and the actor knows that the other person is unaware that the sexual assault is occurring. Okay? Those are just 4 examples of ways in the state of Texas that we can prove that an assault occurred without consent. It's not the only ways, okay, but these are the most common. So, just to reiterate, the idea of just saying no, okay, just saying stop, it's not enough, okay? You have to have something like force being used or violence being used, okay? Now, juror number 21, when I say force or violence, what could that be?
Somebody holding you down and forcing you to do what they want them to do, you know, this stops them from, to make them, commit to something that they're unwilling to commit by force.
Yeah, no, exactly. Juror number 22, what are some other ways that force or violence could be used?
I'm sorry, I can't hear you. Hold on.
Could have spiked your drink and you wake up the next day and realize you assaulted and not aware of it.
And that would probably also implicate the person being unaware or. Juror number 23, what are some other ways that force or violence or coercion could be used?
Like threatening, if you don't do this, I'll do that.
Yeah.
States.
I'm sorry.
Just,
Hold on.
states, I don't know, like coercion, threatening. Blackmail, stuff like that.
Yes. Juror number 24, does the use of physical force or violence, does it have to be hidden?
No.
Are there any other types of physical force that you can think of that could happen during this?
Trains of sorts.
Sure,
I would say holding weapons on somebody.
sure.
Would be
I'm sorry, what?
I would think holding a weapon.
A weapon would be a way that is force as violence.
Juror number 25, any other thoughts on what force or violence could be?
Other than overpowering, I can't think of anything right now.
Juror number 26, what about pushing or shoving? Could that be use of physical force or violence? Juror number 27, what about slapping? Could that be physical force or violence to you? Yes. These are the elements that the state has to do. Okay? If you get selected to be on this jury, these are the 6 things that you should be listening to. And as you hear evidence, and as you hear facts, those evidence and facts should be funneled into one of these 6 elements. So that you can answer the question at the end of the day, did the state prove those elements beyond a reasonable doubt? Did I hear enough evidence on each of those elements say that it occurred beyond a reasonable doubt? Juror number 7. What is this? What's it a picture?
No,
Does anybody know this is a picture? Fair. Juror number 10. What is it a picture of now?
Looks like a waterfall.
A waterfall. Juror number 11. What is this picture of? Wow, that is correct.
I'm sorry. What was her answer? I'm sorry.
Well, no, not false.
Do you know where it is?
Oregon?
It is, right outside Portland, Oregon, okay? Juror number 11, do you have any doubts that that is Multnomah Falls? Okay. Have you been there? Okay. Now, there are pieces missing though, aren't there? Yes or no?
Yes.
How did you know, even with pieces missing, that that was Multnomah Falls?
I grew up in Washington and visited there a lot.
Okay. Was enough of the puzzle done? Was enough of the puzzle done that you knew that that was Multnomah? Beyond a reasonable doubt. Let's say that the entire middle section of that puzzle was missing. Do you think you would be able to say it was Multnomah Falls? Yeah, probably not. Okay? And this gets to an important point. When it comes to the idea of reasonable doubt in criminal cases, it matters how much information you don't hear and what that information goes to. Okay? Juror number 14. Okay? Let's say that after this trial, okay, we were out in the parking lot, and I came up and I sold your place, okay? And you go to the police, and the police question you, would you be able to tell them who assaulted you, or who stole your place? Okay. Let's say though that you forgot the color of my tie that I was wearing, and they asked you, well, do you know the color of the tie? And you said, no, I forgot the color. Would you still be able to say, I know it was the DA because I saw him earlier today? Would that be just a small piece that doesn't actually go to whether or not you knew who did this? Does that make sense to everybody? Now, let's say that somebody came up wearing all black, wearing a ski mask, wearing gloves, and they ran up, they grabbed your purse and they ran away. Would you probably be able to say who sold your first gun? Would that be more information? Would that be a bigger hole in the puzzle? Okay. So, what I want you guys to do, if you're one of the members of the jury, you're thinking about what is reasonable doubt in this case? What could be considered? Or, as to say, proven their case beyond a reasonable doubt, I want yourself to ask these 3 questions. 1, do I have a doubt? If you don't have a doubt, you don't need to go to it. Number 2, is it reasonable? Okay? You know, Sasquatch isn't going to be the defendant in any case. Okay? It's not reasonable. Number 3, does it go to an element of the crime? Okay? Just like our puzzle, you see those missing pieces way up at the top in the trees. We can have missing pieces and still know that it's a picture of Multnomah Falls. We can still know what the picture is, even if we don't have every single piece of information we might want. I don't know about you guys, but when I do a puzzle, I get really pissed when I don't have all the pieces. Okay? But we can still know what the picture is. Now, if we were missing that middle section, it's a different story. But when we have enough pieces to know beyond a reasonable doubt what something is, we don't need everything. Okay? Who likes to watch any of these shows? Hands up, who's brave enough to say that they watch them? Okay. What about these shows or these podcasts? Who's listened to them? Okay? Yeah. I think we all might have, one point or another, seen one or two. In these cases, in addition to telling the stories that they are, at the end of the day, what are they? Stories, what else?
Stories that came from somewhere.
What? So,
Stories that came from somewhere.
so, jury number 77 saying stories that came from somewhere.
Fiction,
Say that again.
fiction.
Fiction. Are they being told for entertainment purposes?
Yes.
Are you going to hear each and every fact that came out in those cases?
Yeah.
No, we're not. So let's talk about what we are going to potentially get, okay, in real life. I've got some answers up there. Who, by raising hands, who would expect to hear witness testimony in cases like this? To see photos in cases like this, who would want that? Raise your hands. Who would want videos? Okay, yeah. Okay, who would want to see the injuries that might have occurred? Judge, can we approach real quick? Juror number 8, as a police officer, though, do we get videos and photos in every case? Juror number 48, do we get DNA and 911 calls in every case? Juror number 77, do you agree with juror number 8 and 40? Does it depend on the type of case, the type of evidence that we get? What am I not going to see? Police reports, evidence of criminal history, hearsay statements. These are types of things that just under the law, we can't do, okay? So even though there might be things that we say, oh man, I would love to see that. There might be things that we can't do under the law, or that we just don't have, okay? I'm gonna skip ahead for time's sake. Okay. The one witness in the state of Texas, our law says that the testimony of one witness is enough for the state to prove their case. Okay? And I'm going to explain what that means. If the state only brought one witness, and that one witness was able to prove every element of the crime beyond a reasonable doubt, the law says that is enough. And it's important, what I just said, that you would have to believe that witness and that that witness proved every element beyond a reasonable doubt. Because remember, at the end of the day, the only thing that the law cares about is were the elements proved, okay? You don't have to go over the top. You don't have to show DNA in every case. You don't have to show videos or photos. At the end of the day, the law just says, was the case proved to you, a member of the jury, beyond a reasonable doubt? And if one witness can do that by themselves, that's enough, okay? So, let's say that, juror number 6, you were in an alley, okay? Like Alfred was in The Dark Knight here, and you got held up at night, okay? There's no security cameras, it's just you and the attacker. You go to the police, you tell them what happened. The attacker never touches you, they're wearing gloves, they're wearing masks, no, they don't wear masks, but they're wearing gloves, so there's no DNA anywhere. They grab you while they're running, okay? Would there be photos of that? Would there be surveillance video? Will the only evidence potentially be your testimony on the stand about what happened? Do you think that the state of Texas is correct in saying that your testimony alone could be enough.
Yes.
That it doesn't require you to bring DNA or more evidence. If you could prove all those elements just with your testimony. So you're saying, I understand that one witness alone isn't it.
Yes.
Does anybody on the left side of the room say, you know, I hear that, I hear what juror number 6 is saying, I would want more. I would want more than just one witness. Does anybody believe that? Okay, can you hold up your,
Oh, I just need clarification.
sure, clarify away,
So the witness is the victim.
sure. Juror number 44?
It just seems like you need something other than just a single accusation, because then it feels like it's a free for all, right?
Sure, and remember, the important thing about this, and we can play it out a little bit more, is that the witness has proven each element beyond a reasonable doubt, okay? So they said, I know who it was this person, okay? So identity is not a question. They told you when it occurred. They told you the type of weapon that was used. You believe their testimony. The question is, even though they told you everything, they proved every element, would you be still sitting there in the jury room being like, I believe them, but I wish I had surveillance video. I wish I had a photo. I wish I had more than just their testimony. Is anybody on the left side of the room, hold up your card saying, I would be that juror. I would need more than just their testimony. And again, I'm not saying that that's what happened in this case, but kind of like the judge said, you have to do the full range of punishment on the bare minimum side. One witness is enough. Would anybody require the state to bring more? You hold up your card and say, that would be me. I would need more. Juror number 1, and juror number 44. Juror number 4 is zero. On the right side, anybody agree with those 3 jurors, that they would be the one in that back room saying, I believe them, they proved to be unreasonable doubt, but I would need more. Juror number 6. Juror number 76. Juror number 73.
Number what?
73.
73.
Just a bottom line of what we said. The defendant can be found guilty based on the testimony of one witness. Even without DNA or scientific evidence, the bottom line is if you believe the witness beyond a reasonable doubt, you follow the law and find the.
That's your time.
Thank you. And last thing, Judge already mentioned this, but if anybody had questions on the range of punishment, did anybody that hasn't already answered that question, say after hearing the state's presentation, I don't believe now that I can view the full range of punishment of this. My last question, anybody after hearing that, juror number 8.
After hearing the definition of sexual assault, I don't think I could agree to probation.
Okay. Anybody else like juror number 8, after hearing the state's word dire, can no longer consider the full range of punishment. Okay. Thank you, guys.
All right, at this point, considering the time that we have 2 options. The first option is that I can let everyone go for lunch. That'll take a while. You'll go away. We'll come back at about 1. Defense will give their jury selection, and then we will finish up. That could put us sometime in the afternoon. The other option is that we just take a real quick break. We push through. The defense has his 1 hour, so he'll be done at about 12:30, and then we can all be done and go home by 1. So you have option 1 or option 2. Who prefers option 1? Raise your hand. I guess we're not doing that. Given no hands. Okay, well, that's good. We'll work through then. So what let's do, don't get up yet, and make sure you leave your cards though. If anyone needs to take a restroom break, let's just do a quick one, 5 minutes. If you're not even going to the restroom, but you want to stretch, you can do that, because I want you to give the same attention to the defense. Once everyone is back, then we can get started. So keep that in mind. Don't dilly-dally out there, because we're going to be waiting for all of you. All right, thank you very much.
That's-
Okay.
Thank you.
You have your.
Not yet, sir. I just wanted to see if they had my screen.
Oh, yeah, we'll get that.
Okay. Just wanted
Go
to-
ahead, please.
Gotcha. It's on there, okay.
I think we're ready to go. Is there anyone that was sitting beside you earlier that's not here now? One over there. Donkey, looks like we're looking for one, the fifth row. Is everyone there on your side? It's good, okay. We're just waiting on one jerk.
Gotcha.
Sir, what number was that beside you? 36? All right, thank you for getting back here quickly. Please give the same attention that you've given to me and to the state, to the defense attorney. Mr. Vickers?
Thank you, Judge. Can everybody hear me? I'm gonna go ahead and apologize. I kind of started to lose my voice, so I might be a little gravelly. Sorry, I don't mean to be that way, but what we're here on today is a criminal case. We've already heard the charge. But I have to introduce you to this text. Could you stand up, please, Mr. Stafford? This is my client, Mario Stafford. And I have to beat this into the ground. Okay? As we stand here right now, he is not guilty. Is that correct? Does everybody agree with that? You've heard zero evidence. Okay? He's no different than anyone else sitting here, right? Because we're all close friends, right? Okay. All right. So our job here is to make the state do their job and to protect this man's rights. Okay? So in order to do that, I'm gonna have to go into some things that are unfortunately uncomfortable, all right? We'll come back to that. But the first thing I want to do is want to tell you one of the reasons why I might yawn, okay? But the more important reason is to do a little bragging. I get to do that on myself. I don't often get to try cases as much as the state does. So I want to show you two little guys. This is maybe why I've lost a little bit of sleep here. These are my kiddos. Ben is the 2-year-old with his I'm 2 shirt on. And Graham just turned 1 about a week ago. So if I yawn a little bit, it's not because I'm bored. It's not because I'm overly tired. It's just because I'm a dad. Okay? One more time. And this is my whole family. You got my dad up there with me, obviously. My mom sitting next to my wife, Lindsay. And then this was before Graham, so Ben was a little bit smaller. And my sister's there to the right-hand side. And then you can see our dogs. We don't have enough of them, if you can't tell. We've got Rita coming around the left-hand side, and then Jake and Gus, my GSPs in the front. So either way, I get to tell you a little bit about myself before we get started. Go ahead. Okay. If we had to boil it down, what is your number one criticism of the legal system? Can somebody give me something? I might have to pick on my buddy Chris here. Now, he already let the cat out of the bag and we know each other. And I don't want to put you on the spot too bad, but what is your number one critique of the legal system?
Correct.
Okay? And I want to ask you, why do you say that?
And I've been party to it on both sides.
I'm sorry, hold on just a moment. Can you repeat your answer?
So because I've been a party to it on both sides.
Thank you.
Would you mind sharing anything about those two things?
Well, in the law enforcement aspect of it, just going through when you, from the whole system of making the arrest to the, preparing for trial, and by the time it ever gets to trial, and then having to re-prepare, because it could be 2-3 years down the road as the officer, as the arresting officer, you may or may not recall every little aspect of the case itself. And it puts a lot of stress on everybody, your family, yourself. And then on the other side, as a defendant, the stress is even greater in the aspect of the fact that it is your life that's in the hands of everybody else there. So the time it takes and persists and keeps going and dragging on, you're still trying to go through your life, and it could ruin it, cause problems or issues, which in my case, it actually did. It took almost 2 years for one of my cases to get resolved on me, and it had a very good toll on my family.
Now, I'm not gonna pick on you too much, I'm trying not to, but you've already said that I was directly involved in that, right?
Yes, sir.
So I was your attorney, is that
Yes,
correct?
sir.
Okay. So you talked about speed, okay? And, did you mention having the memory of the, whatever the elements were, or the incident was, right?
Yes.
Okay, so you would agree that not only it takes a long time, okay, but your recollection can change,
Correct.
okay? Would it also be possible for someone's recollection to change on its own, like additional details, that sort of thing?
Absolutely.
Okay. So if someone was trying to steal man's story, they would have time to do so.
Yeah.
Right? Okay. Some people say that the judicial system is too lenient. Would anybody agree that the judicial system is too lenient? Yes, sir. What's your number? I'm sorry. Can you hold that up for me? Number 6, okay. And I'm sorry, I don't have your name as your number. I want to go ahead. I apologize for that. But why would you say it's too lenient?
There's been occasions where, like, also let out early, or like, thing I was thinking about is like hurricanes hit Louisiana, they let out a lot of businesses. Less than out.
Okay. So do you think that that is due to the trial system or due to the system, the punishment system, in other words, the prison system? Okay, so the prison system.
Yes.
Okay, that's fair. I saw you shaking your head, yes, ma'am, I'm sorry, I don't know your number.
Oh, I understand.
Were you agreeing with this
I
statement?
was totally agreeing with.
Okay, that you think the judicial system is too lenient? Okay. Do you think it is that way in all regards?
Maybe not all.
Okay. You don't have an example for me or anything, I'm sorry. That's one thing, guys, I'm gonna ask questions, and I'm not trying to get too personal, but we're trying to search out whether or not you're gonna be the right juror, and one way is if you have prejudices, or you're not gonna consider things, right? A bunch of people raised their hand and said no probation in this case, right? Everybody agree with me that a few people raised their hand and said that? Okay, so they may not be the greatest juror, correct? Yes, sir, September 18th.
Yeah, I believe it's at least in Hayes County and possibly the Rio Grande Valley is to me.
Okay, and you would say that because you live here in Hayes County, I'm curious to see why you would say that about the Rio
Okay,
Grande.
yeah, I know somebody that's been on probation for probably 12 years for the names, for domestic violence. He would report to his probation officer, all the while, the person he committed the violence upon has died because of the kid. And yeah, you better believe it.
The kid, I'm sorry, you said, was it the person that was convicted of
Let's
this?
say kid, I see this probably in this. He, through the tool chest, the father had an aortic dissection, and there was never a murder charge brought against this child. And they still, matter of fact, still have them coming back for, how are you doing, blah, blah, blah. It's like, killed his father, it's just been so far beyond.
Okay. I understand. I got you, okay. Is there anyone who thinks that the judicial system is overly punitive?
Is overly what?
Punitive. You told your number, sir, I'm sorry. Are you number 9? And why would you say so, sir? Okay. Could you give me an example? So you would say that it's perhaps a racial issue?
I'm sorry, sir, I can't hear you.
Speak up.
A lot of people have biases that they don't acknowledge ahead of time, but you know that they have, it ends up being really punitive for that reason.
Okay. Are there any specific offenses that are treated that way? And ma'am, I'm sorry, let's see, number 17?
I don't know that it's the system itself, but I believe a lot of the cops that are out there today, I believe it's maybe to look.
I'm sorry, what did you say?
I don't think it's the system itself. I think maybe a lot of the cops that are out there, maybe they're trained to look for a certain look, to assume that because a person looks a certain way, then they are more likely to be up to no good. And I know that I have had, my own son harassed by cops and even put in jail whenever he hadn't done anything wrong. And it was proven later that he had not, but not just my son, but, other people I knew, just because of the way they looked. And that's the reason why I think the system is a little bit unfair. I think they aggressively go after people sometimes because of the way they look, looking for a crime that's not even there.
Okay, so would you, not necessarily agree with, but let me see if I can condense that slightly. You would say perhaps that there are biases within, say, law enforcement
Yes.
that would lead to people being in the situation where they're involved in the system. In other words, maybe being accused or arrested.
Yes.
Okay, all right, that's fair. All right. Okay, which leads me to my next slide here. Can law enforcement and the prosecution be wrong? How many hands? Hold your cards for me, guys. I'm sorry. I'm saying hands. It should say cards. Okay. Everybody, right? Is there anybody that disagrees with that statement that they're not wrong? Never wrong. Oh, I thought I had you. Yeah. Quick draw. Okay. Does anybody over there disagree with that statement? That their law enforcement are always right? Sorry to the cops in here, not pointing at you. Okay. The question is, can they make a mistake? Everybody agree with that? Does anybody disagree with that? Okay. What if they make assumptions? If you assume things that you cannot prove, or that there might be a reasonable explanation for, is that wrong if you're a police officer? Does anybody disagree with that? Police can assume all they want. Anybody want to raise their hand? Yes, sir.
I'm not sure I understand the question.
Okay, well, what I'm saying is that if you don't. Okay. You looking at me, you would assume that I'm tall, right? Because I'm standing here in front of you. What if I were wearing stilts? I wouldn't be tall, right? If you had to know how tall I was, you would probably come stand next to me, right? You'd probably, if you could, feel on my legs to make sure my legs were real, right? I know it's a silly scenario, but if you had to know that I was my height, you couldn't assume it, correct? Okay. All I'm saying is that if you assume things, sometimes you rule out things that could be just as reasonable as what you assume. Does that make sense?
I think so.
You might have to ask this question. What do we ask our law enforcement to do in investigating a case? Does anybody have anything? Can I pick on an officer, sir, in the back? What is the first thing that you think of when I say you're gonna investigate a case? You're gonna gather what?
Evidence.
Okay. And evidence can be many things, right? But if you don't look for it, you're not finding it. Is that correct? If you don't take statements, if you don't gather physical evidence, right? You don't take photographs. If you don't visit a scene, right? You agree with all that?
Yes.
And you would have, yeah, let's go back to my question about the scene. If you had never been in this room and never seen a photograph of this room, if someone told you where the doors were, you could recite that, right? But you would be taking their statement as the truth, assuming their statement was true, that the doors are where they are in this room, right? Okay, but you wouldn't know that, right? Okay, and that person could have been wrong. Or they could have misled you, like say if there said there was a door right there. If there is, it's gonna be a steep drop, I can tell you. But it sounds silly, and I know, but we're asking officers to gather evidence in order to meet burdens, okay? And thank you for that, by the way. All right, I know this is gonna be redundant, but do people lie?
Yes.
We just had a bunch of politicians running for office, so I'm assuming y'all would just yell out, yes, I'm here, right? But either way, the thing is that if someone is lying, we ask people to judge their credibility. First of all, we ask during the investigation that they are evaluated by police, maybe the prosecution, if they meet with these people, to, you know, kind of go through their story and see if it has any weaknesses. Now, this is where I'm gonna get to the point where I'm coming to play. I'm gonna have the opportunity to question these witnesses. Is anybody gonna hold it against me if I ask questions that I would not ask you if we were sitting across the dinner table? You understand? Uncomfortable questions. Is anybody gonna hold that against me? Okay, because I'm trying to get to the truth, correct? That's what we're trying to do to present to you. Okay? So I have to ask these questions no matter how uncomfortable they may be. Anybody over here? I'm not trying to ignore you, I gotta make a joke. Back when I was a prosecutor, okay? We called the first few rows the splash zone, and I'm shivering. Okay, no thanks. Okay? It's more likely that someone over here is gonna be on the jury than maybe back there, no offense to you guys. Okay, we're getting pretty high on it back there. Okay, so that may be why I'm looking more towards this direction than I am over here. Okay? So, and I think this question's already asked, and I'm gonna ask it again. Is there anybody that believes because of just the way they are, that it's gonna be hard for them to judge someone's credibility if they're a witness in that box? Anybody feel uncomfortable trying to ascertain whether someone's telling the truth or not? Anyone over here? Anyone confused with what I said? And then you left that there. I'm trying not to tongue tie, and I'm trying not to confuse you, okay? All right. Do you believe a person can manufacture a memory? In other words, it didn't happen, or it didn't happen the way they're describing. Okay, anybody believe that they can't? That their memory is their memory? No? Anybody over here? You hold their cards, I don't have. Okay, so it is possible that someone with either given enough time or maybe being confused, or the other elephant in the room here is that if someone has a mental illness, could they manufacture a memory that was not the way it happened? Does anybody disagree with that? Anybody say, no way, man, I'm not gonna buy that? Has anybody had experience with someone who had that issue, whether it could be through mental illness, and they were a liar, that they told things, they accounted things that were not the way it happened? Yes, ma'am, you 17?
My daughter went for a couple of months with my brother, my brother-in-law, and he did intense counseling with her, and he instilled in her something that never, ever, ever happened, and she believed it until she was doing intense therapy, and the truth was revealed that it was a lie. But yeah, it was something that was told her and instilled in her.
She was influenced.
Yes, correct.
You believe a person can influence themselves into believing something that's not true?
Yeah, out of fear or
Okay.
shame.
Okay, that makes sense, right? We do a lot of things when we're afraid or shame. Is it possible that it might benefit them to tell a story in a certain way? Okay. All right. Now, the next few slides, guys, I'm gonna try to make this as least complicated as possible. But what you're gonna see up here is a statement, okay? And please try to stay within the statement. I know they might not be drafted perfectly, okay? But I've given you a range. If you strongly agree, you're a 1. Okay? If you strongly disagree with the statement, you're 7. Okay? We didn't go 1 to 10. I have no idea why we didn't go 1 to 10, but it makes it a little bit easier. We probably should just go from 1 to 5. That's the truth. Okay? So the statement is the fact that Mario, Mr. Stafford, sits here before you is at least some evidence that the state is right. Okay? Is there anybody who would not be a 7 at this point because you haven't seen the evidence? Do you want me to poll all of you? Is everybody now at a 7 that they strongly disagree with this statement? Anybody this time, please raise your phone. Okay, fair enough, I'll move on. Okay. This next statement is, I would have a tough time voting not guilty if I thought the state was very close, but not quite there. Okay, you didn't believe they had proved an element. Okay. Or a set of elements beyond a reasonable doubt, but you thought they were close. All right. Everybody think about their answer, because I'm gonna have to poll you on this one, okay? So if you strongly agree, you would have a tough time voting not guilty if you thought the state was not quite there. If you strongly disagree, you would not have a tough time voting not guilty if you thought the state was not quite there. Does that make sense? Anybody need any clarification? Okay. Juror number 1. 7. Juror number 2. 3. Okay, I might have to ask y'all to speak up just a little bit because this nice lady's typing everything down.
And I can't see them either.
Okay, I need to.
Just a little bit, yeah.
It's not a great place for my big self. Let me go over here. Okay, juror number 4. 7, 5,
7.
7.
Hold on. We'll have to do this a little bit slower.
why is that? Juror number 5, can I go back to them?
Yes.
Okay.
7.
Juror number 6.
7.
Juror number 8, 7, sorry.
Hold on.
Sorry. 8 doesn't even matter anyway. We know too well. Anyway,
7.
9,
7.
7,
12,
7,
13,
7,
14,
7,
15,
7.
16.
7.
Is there anybody else that's gonna answer anything other than 7? Because you can hold your card up with a skip on this. Is that fair, guys? Sir, number 53?
I'd have to go back one question.
Sure.
You know, to start out with, to even be here today, the state and the police looked at something. I doubt they just pulled them off the street. I'm not saying you.
Well, we are gonna go over I'm sorry, to interrupt you, we are gonna go over the standards here shortly, so. I understand what you may be getting at.
Okay.
But I'm just asking if you were in the jury box and you thought the state was not there on certain things, not quite there, would you have a hard time voting not guilty?
No.
Okay. Anybody else? Are we all at 7? Okay. All right. Here's a little bit more of a philosophical question, maybe, okay? But once again, we've got 1 through 7, strongly agree is 1, strongly disagree is 7. And the statement is, letting a guilty person go free is worse than convicting an innocent person. So does that make sense to everybody? That you would rather convict an innocent person than let a guilty person go free. Okay? I gotta follow you on this one, okay, because I expect some different answers here. Juror number 1. 7. Juror number 2. Okay. Juror number 3. Juror number 4.
7.
Juror number 5.
6.
6, okay. Juror number 6.
7.
Juror number 7. Juror number 8.
7.
Okay. Juror number 9. Okay. Fair enough. Number 10 is 7. Number 11. Number 12. Number 13.
7.
Okay. Number 14.
7.
Number 15.
7.
Number 16. Okay. Number 17. Okay. Number 18.
My responsibility, I don't understand why I have to refer to either or.
I gotta put you in a box somehow. Is that fair enough?
Sarah, in between, because I can't get you. Serious.
So I'll give you a 4. Is that fair? Okay. Sorry, what was your number again? 19?
7.
Number 20.
Say 5, both are bad.
Okay. 7.
Hold on,
Okay,
hold on,
let's see your numbers. I'm sorry. 21, 22.
hold on,
Okay, 21.
hold on. 21,
21 was a 7. 22.
7.
Okay, 23.
7.
24.
7.
25.
7.
26.
Okay.
28. 27, sorry.
7.
28. 29. 30. 31.
7.
32.
4.
4. Okay, we got somebody right in the middle. Good hunch. 33.
7.
34. 35. 5. Okay. 36. 37. Okay. 38.
6.
39. 7.
40. Okay. Yes, sir. Number 41.
4.
4. Very right. No. Number 42.
7.
Okay. Number 43.
7.
Number 44.
7.
Number 45.
4.
4. Okay. Number 46.
6.
Okay. Number 47.
7.
Number 48.
7.
7. All right. Number 49.
7.
Okay. 50.
7.
51.
7.
52.
4.
53. 4. 54.
7.
55.
7.
56. 57.
7.
58.
7.
59. Okay. 60.
7.
61.
4.
Okay. 62.
5.
63.
4.
64.
7.
65.
7.
66.
4.
Okay. 67.
7.
68.
6.
69.
7.
70.
7.
71.
7.
72.
6.
73.
7.
74.
4.
75.
7.
76.
6.
77.
7.
78.
7.
79.
7.
And lucky number 80.
7.
Okay. All right. Okay. Once again, this is a personal question, but I'm trying to ask because we'd like to know whether or not you're making a decision with your heart or your head, okay? So when I make big decisions, I tend to think with my heart versus my head. So you lean towards maybe a more emotional decision as opposed to a logical decision, okay? So if you strongly agree that you make decisions with your heart, you're a 1 or somewhere near there. If you strongly disagree and you make decisions with your head, you're a 7, okay? So is there anyone that would, I'm gonna try to say it a little time. Can you hold up your card if you would be a 1, you make decisions with your heart, strongly agree? Okay, then when I call out your number, could you put it down? Number 2, number 12, is there anybody else? 2 and 12, that's all I got, you're a 1, you agree with that? Okay, is there anybody else who would be, say, a 2 through 4? Hold up your cards, please, I'll call you out, I promise. Juror number 4, juror number 11, juror number 13, juror number 16, juror number 23, juror number 41, juror number 45, juror number 52, 55, 58, 59, 60, 64, 67, and 72. Is that it? Did I miss anybody? Okay,
Sorry, what group is that?
that is gonna be 2 through 4 here.
That's a big window.
I understand. You wanna give me a number? I'll take a number.
4.
4. Juror number 50 is a 4. That's fair enough. If you wanna tell me the number, I'll take it, I promise. Okay, well, I'm gonna do a range again, so forgive me. 4 through 6. If you're a 4 through 6, please raise your card up. Okay, I'm gonna read you off, okay? Number 6, and if you wanna give me your number, you can. Okay. Number 1, sorry. Okay, number 10.
6.
Number 9. Number 14. Okay, 15.
6.
17.
6.
19. 21.
6.
22. 6. 24.
6.
26.
6.
27.
6.
28. 29.
6.
31.
6.
32.
Hold on,
I'm sorry.
31,
6.
And 32.
6.
33.
6.
35. You said 6. 36. 37. 38.
6.
39. 42. Okay, 43. 46. 47. 6. 48. 5, okay. Anybody over here? I'm coming. 51? You said a 4? Okay, you would have been in the last group probably. That's okay. 56. Were you looking for sir?
I was 5 or 6.
5 or 6, 53 is a 5 or 6. 57. 61. 5. Okay. 62. 63.
6.
Okay. 65. 68. 69. 71. 73. 74.
hold
75.
on,
I'm sorry.
Mr. Vickers.
Did I slow down?
Yes, just a little bit.
Okay.
Thank you.
Where did I lose you?
69 was 6,
69.
6.
Okay. And did you have yours up? I'm sorry. 5. And who else on the back row here? 73.
6.
74.
Go ahead.
Okay. 75. Okay. 76. 79. 80. Okay. So if you haven't held up your card, you're a 7, right? Did you hold up your card for me? Okay. I'm just gonna read them out slower this time. 3, 5, 7, 8. We're still up here, man. Wait, we haven't gone off the rails yet. Maybe we have, slowly. 20, 25, 30, 34, 40, 44, 49, 54. Anybody in the second row? No? Okay. 66, 70, 77, and 78. Did I miss anybody? Okay, I promise this will be over soon. All right. Okay, this statement, same parameters here. The prosecution and its team of witnesses would never mislead me. Okay? All right. So if you strongly agree that you would never be misled by any witness or the prosecution or witness brought by the prosecution, could you hold it up? If you strongly agree, if you're a 1. Okay? All right. Is anyone a 2 through 4? Okay. I'm going to read them off the slogan. Anybody in front? Number 5. Please tell me your number, please. 3. Okay. Anyone in the second row? Number 27. 4. You're a 4. Number 22. A 4. A 4. Okay. Number 26.
4.
Okay. Number 28. Number 29. Number 32.
3.
Okay. Number 35. Sorry, I couldn't see it.
Okay, 4.
Number 38.
4.
Number 40. Number 44.
4.
Number 45. Number 46.
4.
Number 47.
3.
3. Okay. Anyone over here in the front row? Number 55. Yes, sir.
3.
You're at 3. Okay. Number 57.
3.
Number 60. 4. Number 61. 4. Okay. Number 63.
3.
Okay. Number 66. 4. Number 74.
4.
Okay. Number 76. Number 77. 4. 78.
3.
3. Okay. Anybody else? Okay. Now we're going to shift over, and this, I guess, everybody said 4. So if there's no more 4s, is anyone a 5 or a 6? Okay. I'm going to have to go slow. Okay. Number 1. Okay. Number 2.
6.
Okay. Number 3.
6.
Number 4.
5.
Okay. Number 6.
5.
Okay. Number 9. Number 10.
5.
Number 11. Number 12.
5.
Number 13.
5.
Number 14.
6.
Number 16.
5.
Okay. Number 17.
5.
Okay. Number 19.
5.
Number 21.
6.
Okay. Number 23.
5.
Okay. Number 24.
5.
5. Okay. Number 25. Okay. Number 27.
5.
Number 30. Okay. Number 31.
5.
Number 33.
6.
Number 34.
5.
Number 36. Number 37. Number 39.
6.
Okay. Number 41.
5.
Okay. Number 42.
5.
Number 43.
5.
Okay. Number 49.
I would say, it's like, way more of the prosecution probably than witnesses. They would not intentionally try to mislead.
Okay. But you do understand that the witnesses are the method in which the evidence comes in, correct?
Correct.
Okay. So no matter what statement they may make, that's not evidence.
Correct.
So in light of that, would you change your number or would you stick with what you have?
That's it, 6.
Okay.
6.
Okay. Number 51, I'm sorry. 4. Okay. Number 52. Okay.
I'm sorry, what was 52?
5.
53.
5.
54.
6.
56.
6.
Okay. 58.
5.
59.
5.
Okay. 62.
5.
64.
5.
65.
5.
67.
6.
Okay. 68.
5.
69.
5.
7.
5.
71. 5. 73.
5.
Okay. 75.
5.
Okay. 79.
5.
Oh, sorry, 72 here.
5.
And she already said you're drunk, what's that one? Okay,
Six.
okay, we say he is 6, okay. So that would mean that everybody else is my 7s, right? Can you hold it up, please? I'll freeze you off real quick. Okay. 7, 8, 15, 18, your card says sideways there. I don't know if I'm dyslexic or in my maybe. All right, anybody else? Anybody else over here? These 7s. Okay. Okay. Once again, I have to ask hard questions. And here's one of them. If a woman says they were sexually abused in any way, then they probably were. Okay? So we have 1 all the way to 7, 1 being strongly agreed, 7 being strongly disagree. Okay? So I'm gonna ask, do I have any ones? Okay. Anyone over here? Okay, I'm gonna read them off over here. Number 55, there were ones? Okay. I'm sorry, did you say so?
Yes.
Okay, so she has to write it down, so we have to have the verbal. Number 53, 1, okay. Number 57,
One.
okay. All right, anybody that's a 2 through 4, coming back. Okay. Number 1. Okay, might have to speak up. Did you say 2? Okay. Number 2.
3.
Okay. Number 3. Number 4. 2, okay. Number 5. 2, okay. Number 9. Okay. Number 11. Number 12.
3.
Number 13. 3, okay. Number 14. I'm sorry, 15.
3.
Number 16.
4.
Okay. Number 18. 4. Okay. Number 19. 3. Number 20. 3. Number 22. 3. Number 23.
3.
Number 24.
4.
Okay. Number 25.
3.
Number 26.
3.
Number 27. 3. 28.
2.
39. 30. 31.
2.
32.
3.
Okay. 33. 4. 35.
3.
36.
4.
37. 38. 39.
4.
40.
3.
41.
3.
42.
2.
Okay. 43. 45. 44. Excuse me. 45. 46.
4.
47. 48.
What was 48? I'm sorry, so. Say again?
4.
Okay. 49.
3.
Okay. 50.
3.
51.
4.
52.
2.
56.
4.
Okay. 58.
4.5.
4.5. All right. Finally, we got a question here. I'm sorry. 58. 60. 3. 61. 3. 62.
2.
63.
3.
64.
3.
65.
3.
66.
4.
67.
4.
69, or 68, excuse me.
4.
And you were 4, correct?
4. Yes.
69.
3.
3. 70.
1.
71. 72.
2.
2, okay. 74.
3.
Okay, 75. Okay, 76. 77. 4. 78.
4.
79.
2.
Okay, 80. 2, okay. So that was 2 through 4. Is there any 5s or 6s? Okay, number 7, can you tell me what yours is?
5.
5?
5.
Number 8?
Hold on, hold on,
6.
hold on.
I'm sorry. I'm having a hard time because I know, so I want to call him by his name, because I know. But juror number 8.
5.
Okay. Number 10.
6.
Number 14.
6.
Okay. Number 17.
5.
5. Number 21.
5.
5. Number 34.
5.
5. Okay, anybody on that back row? 5 or 6? Okay, who's the 5 or 6 over here? Anybody? Number 73.
5.
Okay, number 54.
6.
Okay, number 54 was a 6. All right, anybody else who is a 7? You strongly disagree? No 7s? Okay. All right, next statement I need for you guys. Society nowadays seems to coddle criminals. Okay, that we are too lenient. Okay, if you strongly agree with that, you are a 1. If you strongly disagree with that, you are a 7, or somewhere in between. Okay, so I'm gonna start off again with my 1s. We coddle criminals too much. Anybody a 1? Number 8.
Yes.
Okay. Number 18. What, and you're 1, correct? All everybody a 1. Number 20, you're a 1. Okay. I was expecting you, by the way, but no. I need.
I'd be a 3.
Okay.
It's depending on area too. I mean, I'm taking that into consideration.
Okay, I understand that. Anybody else a 1? Number 61, you're a 1. Number 77, you're a 1.
Yes.
Okay. All right, now, my 2 through 4s. Anybody say we're a 2 through 4? We're too lenient, but not a 1. Okay. I appreciate it. If I call your number out, then give me your number, okay? Is that fair? I feel like it's the worst auction ever, by the way. Number 4. 2 and 4, yes, sir.
4, 3.
Okay.
Hold on.
Is that your final answer? How long you say? Okay.
I'm sorry, I didn't get in it. I don't know what
He was
the
a 3,
answer is.
right? Okay. Number 5.
2.
2. Number 6.
3.
Number 7.
3.
Number 10.
2.
Okay. Number 11.
3.
Number 12.
3.
Number 13.
2.
2. Number 14.
3.
3. Number 15. 4. Okay. Number 16. Number 17.
3.
Okay. Number 19. Number 25.
3.
Number 26. Number 27.
4.
Number 28. Number 29. Number 30.
30. 30. 30.
3. Okay. She threw me off there. Sorry. 32.
3.
Well. Number 33. Number 34.
4.
Number 35. 3. Number 36. Number 37. Number 39.
4.
Number 40.
3.
Okay. Number 41.
3.
Number 42.
3.
Number 43.
4.
Number 45. Number 46.
4.
Number 47.
4.
Number 48.
3.
Okay. Number 49.
3.
Number 51.
4.
Number 52.
3.
Number 53.
2.
Number 54.
4.
Number 55.
4.
Number 56.
4.
Number 57.
3.
Number 58.
2.
Number 59. Okay. Number 60. 4. Okay. Number 61. Oh, you're 1. I'm sorry.
I'm sorry, hold on. 61?
61 was a 1. I'm sorry, I called the wrong number. 62. 63.
2.
64.
4.
65.
4.
66.
3.
Okay. 67.
4.
68.
4.
69.
3.
70.
3.
71.
3.
72.
3.
73.
4.
74.
4.
75.
3.
Okay. 76. 78.
3.
And 8.
4.
All right. So now we're getting on towards the people that do not believe, or that are more likely to say that we do not coddle criminals. Do I have any 5 or 6s out there? Okay, everybody got your cards up? Number 1.
5.
Number 2.
5.
Okay, number 9. Number 21.
5.
Number 22.
6.
Number 23.
5.
Number 24.
Can I say something?
Sure.
Okay, this is such a broad thing, because I think that some classes of criminals are probably way more than others.
Sure,
So this is a hard one for me.
okay.
So
So, if I may ask, then, since you're giving me the opportunity, what do you think we're too lenient on, what do you think we're too hard on?
I think we're too lenient on those that have a lot of money and prestige and power. And probably too hard on those that from lower socioeconomic areas. So.
But you can't give me a specific set of crimes or anything?
I could, but I'm choosing not to say that.
Yeah, I understand.
I'm glad to be later.
Okay. Fair enough.
I guess I would say. Five.
Okay, 5 minutes. All right, let's see here, number 30. 5. 5. Number 38. 5. Number 44.
I know I'm voting out of sequence, but, 4.
4, okay. All right. Anybody over here are 5 or 6? Number 50.
5.
Okay. And number 79.
5.
5, okay. Anybody at 7? We do not call people, okay. Number 3, is that my lone 7? I think it's 10. I'm kidding. I wanna know what you think honestly. Anyone over here at 7? Okay. Okay, we've already asked this question, okay, so I'm gonna go ahead and skip over it. But is there anyone who could not consider the minimum punishment, which would either be 2 years or if eligible, probation? Okay, we already got that. Anybody who just changed their mind since it was asked earlier, is that fair? Because I got you guys, I heard you earlier, is that fair? Okay. Okay. Let's talk about witness credibility for a minute. The sole judge of witness credibility is who in a jury trial? Amen, the jury, right? Not all of you necessarily have to agree on everything, but you would have to find the testimony credible, okay? Does anyone believe that no matter what, in at least this realm, a jury trial realm, that we should do what we can to seek the truth? Would anybody have a problem with that statement? Okay. Okay. I understand the subject matter is difficult in this case. It's not normally talked about. We've already talked about that. I have to ask questions that might be uncomfortable. Okay. Does anybody have a problem sitting and listening to the subject matter of this case? Yes, ma'am. Well, I believe we talked earlier, or heard you speak to this. Is that fair? I mean, I'm not trying to not let you talk, but if there's anything you want to say,
It's just very difficult.
I understand. Okay. So let me ask you a question. Is it possible that someone could be, okay, let me get this. What if something happens to you if you panic? Anybody raise their hand and give me something? Number 10.
Heart rate.
Heart rate, okay, fair enough. Number 9. Adrenaline, okay. I need your card, sir, I'm sorry. Number 38. Hyperventilation, okay. Number 74.
Irrational thoughts?
Irrational thoughts. Could you speak irrationally? Could you not be able to speak well if you were panicked? Okay. Number 33. Okay. Right. Okay. What if it's just enough panic, not necessarily to cause you to fight or flight, but to put you in a scenario that you're uncomfortable with, not used to? Is that fair? There's levels of panic, right? Yes, sir. Emergency.
If I could just add, yeah, fight, flight, or freeze.
Okay, that's true. Could that freezing affect what you said? In other words, you wouldn't be able to get out what you want to say. You're doing it right now. No.
For anybody else, would be off the track.
Right, okay. And sometimes you might make misstatements or not remember things, correct? Is it possible that in a panic, you might manufacture a story? Right then and there. I'm sorry?
Not myself.
Okay, but anyway, I understand you may be a truthful person. I don't have any reason to doubt it. But could someone manufacture a story because they panicked? Is that possible? Does anybody disagree with that? Yes, sir, number 77.
Yes,
They could manufacture a story because they panicked.
yes. Like when we do scenarios in training, we go through scenarios, you're stressed out, get so high sometimes. you need
I'm
breathing.
sorry, sir. Can you start over?
When we do scenarios in training, sometimes our stress level is very high, and when we go back to brief, what we saw, what we tell her in brief, might not match at all.
When you say we, are you talking about law enforcement or are you talking about witnesses?
Law enforcement.
Okay. So even then, in the heat of the moment, you may not remember it exactly like it happened. Is that one of the reasons why you got a body cam?
Yes.
Okay. All right. Have you ever had somebody manufacture a story to you as a law enforcement officer? Any? Go ahead.
Sure.
Okay.
People lie to you.
Okay. And you might agree with me that some people may find law enforcement intimidating. And so they might panic.
Right.
Okay. Even if it was just over the phone, you got a call from a police officer, you might be going, what the heck is going on, right? Okay. So sometimes people are on their guard around you, correct? Okay. All right. I've said this before, so I'm just gonna touch on it one more time. Right now, the presumption of innocence applies. Not just to you guys, to me, the prosecutors, everyone sitting there, the judge, but most importantly, this man right here. Mr. Mario Scott, okay? He's an innocent man right now, and it has to be proven every element that they showed you beyond a reasonable doubt. Okay? Now, he said it correctly, I believe. He said, not beyond all doubt, because we're not witnesses, right? We didn't see the subject matter that happened. I got on hope, because you should be in here. Okay? So, you have to weigh the credibility of the witnesses and the evidence presented in order to overcome this presumption of innocence. So let's go on. Okay. Proof beyond a reasonable doubt. Start with the fact that everyone is presumed innocent. I touched on that. Go ahead. The burden is the state's and never shifts to the defense. This is an important thing. Guys, we could sit here and play tic-tac-toe the entire trial. And if they don't prove their case, your verdict would have to be, say it with me, not guilty. Thank you. Okay? Mr. Stafford, nor the defense has to prove any elements. Okay? They don't have to supply you with any evidence. Is there anyone who has to hear the other side of the story to sit in judgment? Or is going to infer that there's something nefarious going on if nothing is presented? Can anybody raise their card if you have to hear the defendant? Okay. And this applies to every single fact. Okay, the elements of the case. If they miss one, your verdict is, say with me. Thank you. And you, 12 jurors that are put in that box, you must put each and every piece of the state's case to the test. Okay? If something doesn't make sense to you, what did we talk about earlier about assuming? You can't assume if it's not there. Does anybody disagree with me? Okay.
Mr. Members, you have 4 minutes.
4 minutes, thank you. You must rule out all logical and reasonable possibilities, okay? All right, here we go. I want to run through this real quickly. Reasonable suspicion is the lowest rung. You'll see that beyond a reasonable doubt is the highest rung. These are our burdens of proof in the criminal justice, in the justice system, not just the criminal justice system. So the bottom, reasonable suspicion, that is for an officer to stop your car, correct? Okay. Probable cause is for arrest or a search warrant. That's going to get an officer to agree with you.
Right.
Okay. Preponderance of the evidence in a civil case means one side proves 51% or more. Okay. Clear and convincing evidence, the next to top rung. That is the standard that they must prove to remove a child from their home. It must be clear and convincing that the best interests of that child are not being met and removed. Now, I can't give you a definition, but you know beyond a reasonable doubt is the highest above all others. Okay, so the bottom two, reasonable suspicion, that is to pull you over. Okay, to stop your car. Probable cause is to arrest you. Okay? And we have a number of rooms to go. Okay, go ahead. Burden of proof. All right. Top, guilty beyond a reasonable doubt. And I'm gonna let you read over all those. Notice that the bottom says proven not guilty, something that we don't have to do. But on the left-hand side, everything from proven not guilty to guilt highly likely is a not guilty verdict. Is there anyone who cannot abide by that? Anyone said, sir, yes, sir, number 53.
I'm not from here, but where I came from, the judge tells the jury what these things are and the level that has to be reached for a guilty verdict. And I don't know if you're doing that here or if the judge does.
Well, he's gonna do that with the charge and the jury charge. I'm not trying to circumvent that in any way. Okay, I'm just giving examples here of what likely responses are versus what the standard might be.
Just sounds like it conflicts with what the judge is gonna be doing later, but.
Well, I'm gonna let him answer that. Is that fair? And I don't know exactly where you came from, but you said you were an officer somewhere else, is that correct?
Yes,
Where were you?
last.
Okay. I can't speak intelligently on Alaskan law, I'm sorry. Okay. All right. All right, the Fifth Amendment. Guys. No one has to testify against himself. No one has to incriminate himself. No one has to talk to law enforcement. And you can't hold it against them if they do. Does anybody have a problem with that? You have to hear from the defendant. No? So you're not gonna hold that against anyone if they do not speak, if they're accused of a crime. Okay, fair. That's your constitution. All right, go ahead. All right, range of punishment, we've been over this a couple of times, but if found guilty, the range of punishment is 2 to 20 years in prison. Okay, up to a $10,000 fine. You must register as a sex offender for life. And if found eligible, probation can be an option. Is anybody's opinion on being able to consider the lowest or the highest punishment or probation change since we've been talking? We've already asked that.
It's Vickers, that's your time.
All right, that's it. Thank you for your time.
All right, one moment, please, ladies and gentlemen. Can the attorneys please approach? All right, they're going to have a conference just for a moment. That moves things along for us. And then, so you will sit here for just a moment longer. They'll come back, talk to me. We'll find out if there's any of you that need to come forward and talk to me. You will then step outside. They will have 15 minutes to make their strikes. They get to make 10 strikes each. After they've made 10 strikes, you'll come back in, all of you together. You'll sit in any spot, and then we'll tell you who the 12 jurors are, and then you will take off for lunch. So we are almost there, y'all. Just stick with me. And thank you for your patience with us. We should be done fairly shortly.
very much,
Never mind.
or once they have,
They're making their 15 minutes.
right,
Yeah.
yeah.
Thanks. Everybody just- Yeah, yeah. You want to call me. Yeah, he's double chested.
On the,
Yes.
okay, and I'm gonna go by seat, number one. Number two. Number five. Number eight. Number 13. 14. 15. One's 15. Number 18. Number 30. Number 36. Number 36. Number 31. Number 53. Number 55. 60. 61. 66. 72. 73. 70.
Yes, Jim.
Number 40.
This is one that we already. 13 is going to.
All right, ladies and gentlemen, so what will happen is, juror number 29 will stay, everyone else will step out. Hold on before you go, the attorneys will then have 15 minutes each side to make their strikes. At about 10 minutes, we'll invite you all back in. You will sit wherever is convenient for you. You don't have to be in your numbers. Make sure you just don't congregate in the aisles and then everyone has to step over you. You'll get out just as fast. Your cards right now, can you hold those up and then set those down beside you? Don't take those with you because we'll leave them on the next trial. We'll use them for the next trial. And so, again, don't go too far because when we get back in here in 10 minutes, we'll call you all back in. I'll tell you who the jury is and then you'll be on your way. So we are almost there. Thank you very much. You can step out, except for juror number 29. Please leave those cards.
Okay, sure, okay.
You'd come forward, ma'am. Ruby, are you ready?
Yes, sir.
Court call CR 23-5484F, the state of Texas versus Edward Resendez. Can, council please make their announcements for the record?
Allison Boost for the state.
Lorena Garza for the defense judge.
Christian Vega for the defense.
And are you the same Edward Resendez, who in CR 23-5484F is charged with 6 counts of possession of child pornography? You raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth. This is a first-degree felony as charged. State, what is the range of punishment, please?
No less than 5 years, no more than 99 years of life in Texas Department of Criminal Justice.
Do you understand that is the range of punishment that you face for this charge? I have paperwork before me. I didn't swear to you. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. All right. And make sure you speak up because into these speakers, she's taking down everything that we say. I have paperwork before me that is indicating that you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. Pardon me, that's on page 6. There's a stipulation of evidence. It runs into page 7. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement. But if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes.
Counsel, I have the discovery compliance statement before me regarding the state's duty to give you evidence in accordance with Article 3914. Are you satisfied the state fulfilled that obligation?
Yes, Judge.
And do you believe that Mr. Resendez is competent to enter into his plea?
I do so believe.
Mr. Resendez, the reason we talk about the evidence is because you have the right to know the evidence against you. Did you discuss that evidence with your attorney?
Yes.
And are you satisfied that your attorney has provided you with effective assistance of counsel through the course of this case?
Yes.
Are you a citizen of the United States?
Yes.
If not, a plea in a case like this could have serious consequences. According to your plea bargain agreement, the state, in exchange for your plea of guilty, will dismiss counts 1 through 5 and will proceed on count number 6, possession of child pornography greater than 500 visual depictions. The agreed time is for 50 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served in an amount of 355 days. There will be affirmative finding of a visual depiction of child under the age of 10. Is that your understanding of the agreement?
Yes.
And would you like to enter into that agreement now?
Yes.
To the charge in count 6 of possession of child pornography greater than 500 visual depictions, how do you plead?
No content.
You can plead no contest, or you can plead, that means we're gonna have to go through evidence. State, you have an agreement on
Judge, the
that?
state is not
Step
willing
back and y'all
to
talk about
accept a
this.
no contest plea on this.
Step back and talk about it. We're off the record. Okay, back on the record, Ruby.
Yes.
So we're to the point now where I have gone through that plea bargain agreement as it's listed here. Did I go over that agreement as it's listed? And now to the charge in count 6, a possession of child pornography greater than 500 visual depictions. How do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
Is anyone forcing you to plead guilty? Is this what you want to do?
Yes.
State, have you given notice where appropriate on this case?
In this situation, Judge, we were not able to identify known victims of the child pornography to notify.
Okay. And given also that in the stipulation of evidence count 6, it includes the language. It is further presented that the visual material depicted a child younger than 10 years of age at the time the image of the child was made. Was it your intent to stipulate to that evidence that the depiction of the child was under the age of 10?
Yes.
Okay. If you need to ask a question of your attorney, you may. This goes to the issue of the affirmative finding.
Yes.
Okay. Then I find that there is a visual depiction of the child under the age of 10. I find that there is sufficient evidence to substantiate your guilt for count 6. And find that you are guilty. Is there any legal reason we can't proceed to sentencing?
Nothing from the state.
Nothing for the defense, Judge.
All right, having found you guilty in count 6, possession of a child pornography greater than 500 visual depictions, the court now sentences you to 50 years in the Texas Department of Criminal Justice. You will get credit for the time you've served in the amount of 355 days. There will be an affirmative finding of a visual depiction of a child under the age of 10 as you stipulated. Is there anything else we need to take up?
Nothing from the state.
Nothing from the defense.
Sir, I followed your plea bargaining agreement, and because I followed your agreement, you do not have a right of appeal. I'm signing the trial court certification that says so, and we'll add that to your file. Good luck to you, sir.
Mr. Sanders, I need to borrow your right thumb real quick. Straight down, and then straight down in this way. You don't need to roll it, just straight up, straight down.
Go to detention.
Defense, you ready? It's been 20 minutes, please.
Yeah.
I'm good.
Come on, sir.
Any spot will work. The front row is completely open, everyone, both sides. Deputy Domke, can you please come check the names? Oops, I'm waiting for him. Can the attorneys please approach? Let's see if they want to get this. Be great if you. Sorry. Maybe this.
Yeah.
Okay. Great. No objections?
No objections. No objection, Judge.
All right, I can step back. All right, if I call your number, please come and take a seat in the jury box. Number 3. 6. 19. 23. 23. The cards you're holding up, that's right. 27. 29. For the cards you're holding up. Number 30.
Very approaching.
Okay, well, I'm, now we can see who the jury is, we can make that change, that's why I'm asking. Check and see. Just one here. We did do a check there. Just one. We look back on. Add. So we want to proceed. Yes. Number 30.
She's up.
There. Number 31. 32. 33. 35. 37. Number 35 come up? Number 37? It was your card, 37? Would have been sitting on the left side. Who was 36? Does anyone remember sitting by 36 on your right? So you're 37?
Yeah.
All right. Check that for me. Good?
Yes, sir.
All right, anything from state?
Nothing from the state, Your Honor.
Thanks.
Not this time, Your Honor.
All right. All right, ladies and gentlemen, we now, if you've done the math real quick, that's the 12 that will be our jury. That means the rest of you in just a moment will be free to go. Let me first thank you so much for coming here. We couldn't get to these 12 fair and impartial jurors if we didn't have you all come and participate in this process. Be honest and tell us the way you feel about the cases that are in front of us and about the issues that are in the criminal justice system. Today, we just took a step forward in getting a more just system because we're going to put 12 fair and impartial people on a jury. So thank you so much to all of you for coming here. Now, I told you that throughout this time that I hope this process builds your confidence in the system. You see what we do to get a jury. We see how we go through all of these steps to get a fair jury. And so what I'm going to ask you to do is that as you go forward, you let people know, come to jury duty. It was great that we got to send some people home. We're having people that are showing up in higher numbers than ever. And I believe that part of it is because jurors are leaving and saying, look, they're not going to waste your time. We're taking care of you. I know it's 1:30 and your stomachs are grumbling, but you won't have to come back. All right. So thank you for being patient with that. Here's the thing. When you go and vote, many of you just got that sticker. When you get that sticker, it's because they want other people to see it and think, oh, I need to go vote too. I think we need to be doing the same thing with jury duty. So I made up my own little sticker. All right. And I mean this, you now are all the ambassadors. When you go out, let people know that what we are doing here in Hays County is to look out for people who need to settle their disputes in court. When the state needs to bring a case, when a defendant needs their case heard, the people are showing up for it. So when people ask, they get that summons in the mail just like you did, and they open it up and they go, oh no, what do I do to get out of it? I want you to tell them, no, you should go. It's important, it matters, and we will respect your time. Thank you very much for being here. Y'all have a great afternoon. The stickers are there in the back. You don't have to take them. If you want one, you can. Have a good day. Yes. Are you ready?
Yes, sir.
All right, ladies and gentlemen, you will be our jury in this case. What I first want you to do is if you would all rise for me. Raise your right hand. Will you render a true verdict based on the evidence and the law in this case?
Yes.
All right, you may be seated. All right, you are now all sworn in as officials of the court, and so there are a few instructions that I need to give you. Do not talk about this case with anyone. Do not text about this case with anyone. Do not put anything on social media. So to make it easy to remember, don't talk, text, or tweet about this case. The reason is that we don't want you to be talking about this case, including to your spouse. And you say, well, it's a case about X crime or X offense. And then they say, well, you have to do this, or someone starts influencing you. Understand that what we want here is for you to make your decision based only on the evidence and the law that you hear. When the case is up, you'll be able to talk to anyone about it and talk to anyone about it. So that means you won't look up anything on the internet. Don't try to look up what the law is. Remember, I will give you the law, and you can look it up. Next thing you know, you're looking at California law. And we're not doing California law in Texas yet. There might be a lot of Californians here that want to come to Texas, but we're not going to use their law. Don't go to any, once you find out the locations, don't go do any investigations on your own. Don't go looking for evidence. Don't do any experiments. This is all to protect the integrity of the case. You will make your decision based only on the evidence, which comes from the witness stand and from the materials that are admitted into evidence. Also, that means putting anything out on social media. The same way someone could talk to you about it. If you were talking, you put something on social media and they respond to it. We just want to protect the integrity of this process. That's why we have all these rules. Now, so what we're going to do is we're going to take a lunch break, obviously, given the time. Deputy will take you to the back and show you how you will come in and out of the building and back into the room where you all will be located. It's 1:35. We will start back at 2:45. And the reason is that I believe, and from talking to the jurors, that if we pick in the morning and then we don't do anything in the afternoon, people say, I already took off the day. I want you all working. So we will be here. We will begin working at 2:45 and we will end at 5 o'clock today. I will not keep you any longer than that. We will stop whatever witness we are on at 5 o'clock. And then tomorrow, so that you know a plan, we have a full docket in here in the morning, and we will start the trial at 1 o'clock in the afternoon. All right? Keep those rules in mind. No talking, texting, or tweeting. Don't look up anything about this case. You can tell them you're in the 483rd Court. You can tell them you're in front of Judge Neidhardt if you want to, but do not talk about the case with anyone. All right? Deputy?
All rise for the jury.